And Russell Brimelow, wherever he is has kindly joined us again, and is going to talk through some current hot topics. Now, Russell's a well-known employment lawyer and partner at Lewis Silkin, one of the top-ranked employment practices in the UK. His work primarily involves advising substantial, often international employers on employment law, many of which are in the media, IT and publishing sectors. Welcome, Russell. Oh, there you are. What where you are.
Good morning, everybody. I hesitate to come up here, actually, having been the purveyor of some of these solicitors' letters and nasty words. But I do have two pieces of good news for you today. First, you're going to talk to a lawyer, or hear from a lawyer at least, who isn't going to talk about downsizing or restructuring or outsourcing, which is quite an unusual event, frankly, for all of my clients at the moment. And the second great thing is that April isn't the cruelest month. Thank goodness we've got some good pieces of news. We are actually going to get rid of this ridiculous statutory dismissal procedure, statutory grievance procedure nonsense we've had for the last 5 years. And I was actually going to be very sort of self-indulgent and put up an article I wrote in Personnel Today back in 2003 saying this is all going to be a complete nightmare. We're all going to have horrible times looking for grievances, etc. But I decided not to do that because obviously I'm a very modest and unassuming lawyer. But I'm going to talk to you a little bit about obviously celebrating the fact that we don't have this wretched series of Step 1, Step 2, Step 3 from 6th of April. Talk to you a little bit about the new Code of Practice and the new rules which are coming up in April. And I think it'll be a relief, but I'm going to share with you some of the comments that some of the commentators are making, saying this is just going to be the son of the SDP, there's still going to be uplifts, and there's still going to be a lot of satellite litigation, satellite issues around that you need to be aware of. So we'll deal with that. I'm also going to be giving you a heads up on the new Equality Bill. This is the enormous piece of legislation which the civil servants have been working on for at least a year and a half now. It's going to basically take every piece of discrimination law. There's about 100 plus bits of legislation. They're all going to squodge into one act, and they're going to streamline all the discrimination laws. And as I say in the slide, it's not just codification. There's going to be some new goodies in there as well. We're not quite sure exactly what, but I'll give you the heads up on what we know to date. The next issue, working time issues, looking at what's happening with the opt-out, the holiday issues, big case on that, more holiday coming up in April, and some further complications. Looking at increases in flexible working. One of the areas in employment law which I think has worked really well, actually, over the last few years, the right to request rather than the right to have or the right to impose. And if I get more time, do wave at me if I run over time, because I always get very enthusiastic and start chatting away about all sorts of things. We'll look at some more case law, some recent announcements, and if anyone's got any questions, I'll be delighted to help you. And if not, in this session, then over lunch and later in the day. So, good riddance to the dispute resolution procedures. I've put up this quote, actually, which came in a case about 3 or 4 months ago from Mr. Justice Elias, who has been the head of the Employment Appeal Tribunal for the last 2 or 3 years and is now going into the Court of Appeal. And a very sensible gentleman he is too. Rarely can legislation have been so counterproductive. And I'll let you read the rest of that. But it really has been a complete nightmare for lawyers and obviously for HR practitioners over the last few years, just working out what's a grievance, have you done your Step 1 letter, if not, how do we avoid automatic unfair dismissals? It's been a complete pile of you-know-what. So, no more. There's no more automatic unfair dismissals coming up in April. We don't have to play spot the grievance, although you might have seen we've even got a case 2 weeks ago talking about different aspects of grievance spotting from the EAT, and thank goodness this is all going to go, because I just think forcing employers and employees to go down a very formal route has been very counterproductive. I don't know if you've sort of nod at me the number of times that you've sat around thinking, well, should we go the formal route? Isn't that going to just make things worse? I've seen a number of cases where people being forced into a grievance procedure has just actually polarised the issue rather than solved it. There's no more 50% variations in compensation to worry about, although, as we'll see, there are 25% variations. But that can make a big difference. I had a case the other day where somebody was claiming discrimination, disability discrimination, and the uplift in itself would have been over £500,000. So, you know, these are big issues from time to time. There's no more claim barring of claimants. So previously, currently the rules said if you haven't brought a grievance and it's not about a dismissal, then you can't bring your tribunal claim. And the tribunals absolutely hated that and tried to get round it by all sorts of ways, and thank goodness that's disappearing as well. Finally, and not least by any means, the fiddly extended time limits. You know, when is it 6 months, when is it not 3? All that sort of stuff is going to be disappearing, and that's a great piece of good news. If you want a piece of good news at this conference, frankly, I think this is the biggest. But, and there's always a but with lawyers, I'm afraid, what we do have is a new code of practice. It's 10 pages long, and what it sets out to do is really just give the ground rules for disciplinaries and grievances. It doesn't apply to dismissals for redundancy, and thank goodness it doesn't also apply to the expiry of fixed-term contracts. And you know, those of us who do a lot of media work, I mean, every media company I know has lots and lots of people on fixed-term contracts. So that's been a real pain in the arse, actually, in terms of saying to people, well, sorry, your fixed-term contract's come to an end. Here's a step 1 letter. Let's have a step 2 meeting. Here's your right of appeal. It just doesn't work in that context. And thank goodness that's now been removed from the equation. As I've mentioned before, there are 25% variations in compensation available to the tribunal if you have unreasonably failed to comply, the next point down, with the code of practice. So the code of practice, I've got a copy of it with me today if anyone wants to have a look at it, is going to be the holy grail. And if you fail to comply with it, then you've got this risk of an uplift or a decrease in compensation depending upon which side of the fence you're on. And there are, in that, possible new pitfalls for employers. I suppose the one aspect that was useful and reliable about the current system we've got now, the step 1, step 2, step 3, is at least you knew that if you ticked off step 1, step 2, step 3, you wouldn't fall foul of an automatic unfair dismissal. Now you've got 10 pages of obligations, and you've got to comply with all of it. But your risk is only if you unreasonably fail to comply. So the liability risk is a lot less. So, what are the pitfalls for employers? Well, I think the problem is, in a nutshell, this new code has not been written in a legal sense. It's not written by lawyers, it's written by ACAS. And it's meant to guide people in plain English, which is great, but the tribunals will look at it in a very legal sense. We had a case, you've probably seen it, about a month ago, where a High Court judge was looking at the rest break provisions in the working time regs. And he was saying, well, what it says is, if you work more than 6 hours, you get a 20-minute break. And this person worked 18 hours. And the judge said, well, we have to look at it very legally. You only get one 20-minute break. So even if you work 18 hours, you're still only entitled to that one break. So very literal, very anal, one might say, way of looking at these things. And I'm afraid that's what lawyers are a bit like. And now we've got lawyers poring over this 10-page code of practice and making points. I'm sure we'll see lots of correspondence saying, what you've done isn't quite in accordance with paragraph 23 of the code of practice. You know, we put you on notice, we'll be asking for a 25% uplift. And that's the sort of thing you'll see. But you won't be quite so worried about it because you're not looking at automatic unfair dismissals and obviously the uplifts are much lower.